Good evening, everybody. Thank you for joining us this evening. I'm just going to go ahead and just wait a few more minutes. It's 6 o'clock now, and I'm just going to wait for folks to kind of trickle in, and we can begin this evening's presentation. All righty, folks. Well, it's 6:02 and I kind of don't want to hold anybody up. So I'm just going to go ahead and begin. And I want to say thank you so much for joining us this evening to kind of talk about some tenant rights and tenancy rules, things that we normally see on a continuous basis here at Echo Housing. And our contact information is going to be at the end of the presentation if you want to reach out to us. You have any specific questions about a specific situation, more than happy to take your call. I just want to make sure that people can hear me. If you can raise your hand, let me know if you are able to hear me. Thank you, Richard. So it looks like, yes, you can hear me. Okay, so we're just going to go ahead and begin. So today's presentation, we're going to kind of touch on a variety of different topics. As you see on my screen, we're going to talk about things before you rent, the rental application, holding deposits, your rental agreement, security deposits, and then we're going to end with talking about the Tenant Protection Act, specifically in terms of evictions, and what that means for tenants and landlords. So a lot of information today. Please, if you have any questions, submit your questions in the Q&A box, not in the chat box. So if any of you have any questions, just type them in the Q&A box and I will definitely read them out loud. So a little bit about us. So Echo is a qualified fair housing organization under HUD. And so our principal role is really to investigate complaints in terms of discriminatory practices that managers or landlords may be exhibiting against tenants. But we also provide tenant landlord counseling. We interface a lot with tenants who are calling us about what their rights are, what they should be doing, helping them explain to them what the eviction process looks like. So we provide a good chunk of services in those two aspects. Again, our telephone number is on the screen, and the address you see is our administrative office located in Hayward. So just a disclaimer, all the information that you see in today's presentation is only for general educational purposes. This is not legal advice. We are not here to provide you legal advice. And so if you do need assistance with legal advice, I do request that you do reach out to an attorney so they can better guide you. So before you rent, well, actually, let me backtrack a little bit. So we're going to go ahead and begin basically the crux of today's presentation. And again, please feel free to type in any questions you may have during the presentation. So before you begin to rent, one of the most important things that I see many tenants fail to do is do an inspection of the rental unit with the landlord or the manager or whoever is the assigned agent. Tenants should not be signing a rental agreement without ever inspecting the unit. Many times the issues that I see have to do with the fact that the tenant did not do the inspection. Now, if the tenant chooses not to do the inspection, that's perfectly fine. But just know that a lot of these issues that you may have during your tenancy are prevented if you actually do an inspection. The reason why I always recommend an inspection is because it allows you as the tenant to make requests for the repairs before you move in. A huge red flag I see many times is you go look at the unit, you inspect the unit, you're asking for repairs, and the landlord doesn't want to do them. In that case, I probably would just walk away. I wouldn't sign an agreement. The landlord's already indicated to me that they're not proactive. They don't care to do any repairs. So again, most important thing is you need to do an inspection. It's not required. The law doesn't say you need to, but I always recommend it because it's gonna protect you. In addition, the inspection also allows you to take photos of the damages that have occurred on that unit before you moved in. And later on, when we talk about security deposits, this inspection is going to be extremely important because we get many calls regarding inspections. And when I ask questions, it's like, oh, I don't have photos. Oh, I didn't do that. But so then you don't have a really good claim because there's no way to prove that when you moved in, it looked in this condition. And when you moved out, it looks at this condition. So again, please do the inspection. In addition, I always find that having the inspection also allows you as a tenant to kind of see how the landlord's going to react with regards to your concerns. And so it's just super important. I can't stress that enough. I will say a good chunk of issues come down to this inspection because there was never an inspection. And the other thing that you want to ask before you sign a rental agreement is who's responsible for paying utilities. Many times people will get a rental agreement and the only thing they care about is what is my security deposit and what is my monthly rent. And they don't read about the other additional charges that you may be assessed. And so if you're thinking that your rent is going to be $1,600 and it turns out to be $1,800 because you're going to be paying these miscellaneous items, you want to know upfront. And that's just for budget reasons. So in the rental application, it's just like a job application. And just like in a future employer, they need to decide whether they're going to rent to you. And so part of that is that part of the rental application, they're going to be asking things like your past employers. They want to make sure that you're able to afford this rent. Now, they can't ask you, well, what type of work do you work in? Because that may be discriminatory. Or they can't say, well, because you're a nurse, I don't want to rent to you because you may get my other tenants sick because you work in a hospital. That would be discriminatory. But they can ask and verify that, yes, you do have a job in order to pay for rent. They may also ask to contact previous landlords. And I say this because part of trying to figure out how was your tenancy previously, who did you pay your rent on time? Do you owe back owed rent, for example? They want to know how were you in your previous unit that you used to live in. Contact information for references. Now, criminal history information, I think that's been removed. Don't quote me on it, but I think I recently saw something that they can no longer ask about criminal history. So for right now, it's in the air. They can ask about driver's license number to verify who you are, your identity. And as I mentioned here, under fair housing laws, it is prohibited to discriminate against source of income. So some people may receive, say, Social Security income. That is legal income, and they can't say, well, we're not going to rent to you because you receive Social Security income. Unfortunately, that would go against the current fair housing laws. So again, don't quote me on this criminal history thing because I believe it's slightly changed. And I took some of this information from one of our previous presentations. But from the most recent reading, landlords may check the criminal history of a potential tenant. Again, they have to make an assessment. So something that they cannot use as part of deciding whether to approve you for your tenancy is arrests that did not lead to a conviction. If you participated in pretrial or post-trial diversion programs, most people will know what that is if you've had to go through pretrial or post-trial diversion programs. Any records that have been sealed by the court, and then convictions that came from the juvenile justice system. So if a landlord does intend to deny you housing based on past criminal history, it has to be based on past criminal history. It can't be on, I don't want to rent to you because you have the potential to cause crime in the future. So we see this a little bit, but it comes up here and there. So other things, credit reports and domestic violence. I do apologize for the little cutout on the presentation. So your rental application may contain an authorization for the landlord to obtain a copy of a credit report. Again, they want to see if you can manage your finances. If you're somebody who doesn't pay your bills on time, you have repos, etc., they're making an assessment of the likelihood that you would not pay them for rent. And I get this many times is that tenants call us and say, they're very upset because the landlord doesn't want to rent to them. Well, if you've shown a pattern of behavior with your finances, there's a likelihood that you will also not be able to pay rent either. And you will find that in some apartment complexes or landlords, there is a minimum credit score. They can do that. And so as long as if they're going to deny you because of your credit score, they do have to disclose that the factor was because of your credit score. So they are allowed to do that. As I always mentioned, when you are trying to rent a place, you have to prove and show that you are a responsible person and you can make your payments on time. In terms of domestic violence, it is prohibited for landlords to discriminate against tenants because they are survivors of domestic violence. There are federal laws that do protect those who are victims of domestic violence, and you don't necessarily see it a lot, but they do come once in a while. And so a landlord can't deny you just because you are a victim of domestic violence, especially if you live within some type of subsidy program. And the same thing goes with evictions. They can't evict you just because you're, the police were called and you were a victim of domestic violence. So application screening fees, you're most likely are going to be charged an application screening fee. And this is for the landlord to cover the cost of obtaining information regarding, and I apologize for the typo. I get this not a lot, but once in a while I'll get someone who calls me and says, "Hey, Jonathan, I've been applying to 15 places and I have to pay this fee every single time." Well, because you're applying to different places. So unfortunately, that is the norm. The norm is that you will pay an application screening fee because it costs money to go and find your information, to contact that third party who's going to run your credit check, your background check. None of that is free. Nobody works for free these days. And in 2020, the fee or the application screening fee cannot be more than $52.46. And I do tell people, if you don't like the landlord screening fee, then go find somewhere else to go live, because they can set those fees. They can decide if they're going to charge you or if they're not going to charge you. I know it's a little bit easier than said than done, especially if, you really need to find housing. But the truth is that most places are going to ask you for the screening fee. And the fee is not refundable. Okay. So, this is something that comes up quite often, especially with households who have to pay quite a few fees for different apartment complexes. They're not refundable unless the screening never took place. Now, you're probably going to say, "Well, Jonathan, how do I know if the screening took place or not?" I don't know. That's very difficult to tell. It may show up on your credit report that somebody or, this management company looked at your report. Who knows? But the truth is they're not refundable, which is why it's really important that before you submit an application screening fee, that you've gone and looked at the property. Because the common issue that I see is folks submit an application fee, they look at photos online, they really like it, then they magically go and they go see the property and they want to back out. Unfortunately, you should have done that before you submitted the application fee. Holding deposit, this is something that I'm seeing quite often lately. And basically a holding deposit is a deposit used to take a rental unit off the rental market. So basically you're putting a hold. I always tell people, always get a holding deposit agreement in writing. And I say this because if you have it in writing, you'll be able to know if you're able to get a refund on the holding deposit, if you decide to back out, or what happens to that holding deposit once you move in. Does it become part of your security deposit? Is it applied towards the rent payment? As a matter of fact, I got this question today from a tenant who they didn't sign anything. And so I was like, well, I can't tell you anything because you don't have anything in writing. I can't tell you that you get it refunded or not. So the key important part here is if you're going to put a holding deposit, please get the terms and conditions on a piece of paper. If they do not want to give it to you, then you should walk away. Find somewhere else to go rent. Because if you need to back out, that agreement is going to outline what happens to that money. In many instances, the holding deposit isn't refundable. That's just the way the contracts are real, these types of agreements are written. So I do tell people, if you're going to put a holding deposit, be almost 99.9% certain that you're going to move in, because holding deposits can be as little as $300. And that's a big chunk of money, and they can be as high as 1 month's worth of rent. So that's a lot of money to lose if you move out. And as I mentioned, if the applicant is approved, but the applicant fails to sign or move into the unit, they may lose the holding deposit. And unfortunately, you need to have everything on a piece of paper. I cannot stress that enough. And I'm going to talk about paper trails as we go through this presentation, but please ensure that you have everything in writing. Because if you don't, then you're asking for a disaster in the future. So the rental agreement, I cannot stress this enough. Before you sign the agreement, make sure you understand every term. You may get a rental agreement that is 15 pages long, 30 pages long. It is the tenant's responsibility to understand it. I will say, just as I mentioned in the beginning, you knowing what your agreement says will help you in the future when you have problems. If you are being pressured to sign an agreement without understanding, then you should refuse the unit, because you are going to be responsible for the rules outlined. I can't stress that enough. Many times I get tenants who say, well, I didn't read that part of the agreement. Well, that's your problem. That's not the landlord's, that's not the manager's. You have a responsibility to read what you sign. And it's that simple. It can be little things, little provisions on the contract that basically can harm you in the future. For example, I saw someone's rental agreement today that said, if there is serious habitability issues in the home, the landlord may put you up in a hotel or begin the termination process. And guess what the landlord did? The landlord began the termination process, and it's outlined on their contract. So there's no surprises. If you read everything, you should not be surprised. If you don't know what it means, ask. I'd rather you ask than you think you know what it says, and then in the future, it harms you. Your rental agreement should have some basic information, such as the names of the landlord, who's actually going to be authorized to move in, the address of the unit, how much is rent, when is rent due, to whom it is paid, and where do you make payment, the amount of the secure deposit, and then one that I see often is, are pets allowed, and the number of people that are allowed to live there. I think this is usually kind of the bread and butter of the rental agreement. But again, there are other provisions of the agreement that essentially outline what you can and cannot do on the premises. Again, who's responsible for paying utilities, and then who are you supposed to contact in case there are some issues with the property, and then any other tenant rules that the landlord may impose. Again, if you think that what you're reading is not fair, you can either try to negotiate a more suitable agreement. And if the agreement is made, make sure it's in writing, people. Please make sure it's in writing. Do not trust anybody when it's just verbal. It's not going to work. You need to have everything in writing if you want to protect yourself. If you're not able to negotiate better terms, then consider if you want to sign the agreement as is or continue your housing search. Again, I know it sounds a little bit easier than to do, but the truth is that you're signing this contract that obligates you to those provisions of that lease. You violating those can cause for you to be terminated. You not understanding what procedures they may have can then pose later on more issues. For example, you may be imposed fines for certain violations, etc. So you need to read what you sign. It is so important. I see this on a daily basis that people don't know what in the world they're signing, and they just go and sign it. And that puts you in a much worse position, because then you don't have wiggle room to try to help yourself out of a situation. So I'm going to transition and talk about secure deposits because it is usually a big topic of discussion. And so basically the law limits the total amount that a landlord can require you to pay for a secure deposit. And the rules are usually that if this is an empty unit, they cannot charge you more than 2 months of rent. So in this particular instance, if your rent is $1,200 a month, and it is an empty unit, they cannot charge you more than $2,400 a month. If this is a furnished unit, which I don't necessarily see a lot of furnished units, they cannot charge you more than 3 months of rent. So a landlord, this is what I call the secure deposit rules. Essentially, the question that we normally get is, the landlord doesn't want to give me my secure deposit back. What are the rules? So the rules in which the landlord can use the secure deposit fall under these 4 rules. The first one is if you haven't paid, if you owe rent, they can use that secure deposit when you move out to cover that rent that you haven't paid. The cleaning of the unit when you move out, but only to make the unit as clean as it was when you first moved in. The next question that someone's going to ask me is, well, how am I supposed to know how clean it is? Well, did you take photos when you first moved in? Did you do an inspection when you first moved in? And if the answer is no, then how are you going to prove your case? You need to document everything. Even if you're renting from your cousin Susana, you need to document everything because you need to protect yourself. The landlord may use the deposit to repair any damages that were caused by you or your guests. So this is key. If you invite people to the home and they cause damage, you as the tenant are responsible for that damage. And then finally, if the rental agreement says that, you have to restore or replace certain furniture or personal property. The most common one is going to be keys. That's something I see quite often. And it's ridiculous. I've seen them where it's like, it's going to cost you $100 for us to replace the keys if you don't turn in your keys. I mean, that's just a ridiculous charge, but it's written in your contract. So again, going back to the previous slide, you have to know what your contract says, period. There's no, well, I didn't know it said that, or I didn't understand that. It doesn't matter. If you sign it, that means you are responsible for it. So returning your secure deposit, the rule is that the landlord has 21 days from when you moved out to do several things. The first thing is send you a full refund or send you a partial refund with an itemized statement that lists what those deductions are. And the third option is, which I didn't write on here, is that they can withhold the entire secure deposit. As I mentioned in the previous slide, maybe the damage is way more than your secure deposit. And so that is why, you didn't receive anything. So the landlord cannot refuse to return the entire secure deposit just because you lived in there. Your secure deposit is refundable. They can never say that it is not refundable, because that's not the case. The secure deposit is there in case one of those 4 rules are violated. And then again, the secure deposit cannot be used for repairing defects that existed in the home before you moved in. The first question I'm going to ask is, did you take photos when you first moved in? Did you take photos when you moved out? And if the answer is no, then there's not much you can do because you need your proof. People, we live in the 21st century. Everybody has a cell phone. Everybody has a cell phone with the camera and video capabilities. Take your photos, take your videos. So what if the owner decides that they do not want to return your secure deposit? You have 2 options. The first option is you're going to write a letter to the owner explaining that the deductions are not warranted and demand a refund. And you have to provide the proof. If you don't got no proof, then what are you fighting? So you need to have your proof, okay? The second step is if, say, you sent them the letter a month ago and they ignore you, you can file a small claims court lawsuit. Now, small claims can be a little bit tricky. I know that for folks, the Monterey College of Law, which is, I believe, in the city of Monterey, they do offer kind of some assistance in filing the small claims, but they do charge a small fee. So usually legal aid agencies don't assist with small claims, and many attorneys also don't assist. They may charge you to help you fill out the documents, but again, that's a step that you as a tenant is going to have to decide if you want to pursue that. And it does cost money for you to file with small claims, so that's another added expense that you have to think about. Any questions? If there are any questions, please submit them in the Q&A box. Okay, it looks like we don't have any questions. We're going to continue. So I'm gonna switch over and, we kind of talked an overview about things that you should be thinking about. Actually, it looks like someone did post a question. Yeah, so someone is asking, how do I resolve an issue I am having with the neighbor tenant that puts his music loud? So the first question I probably ask is, when are they playing music? Most cities, most counties usually say that people can play music between this hour and that hour. If they're playing music between this hour and that hour, then you probably can't really do anything. If the music is usually after hours, and I don't know in your area if after hours is like after 10 p.m. or after 11 p.m. Then I always recommend people to call the police, so they can diffuse the situation. And second, by calling the police, you have a running record of these issues. If this is a neighbor that also rents, then once you have that running record, you want to write a letter to the owner. If it's a different owner or a different apartment complex, then you write the letter to that owner. But the first step is going to be, you need to call the police. I know it sounds a little petty, and I know it sounds a little bit childish. You're obviously not going to call the 911 number. You're going to call the non-emergency number. Because again, you want to have a running record that this person is continuously playing music outside of the allowable times. If this is music during the period that they can have music, there's really nothing you can do. They have a right to play music because the city allows them to have music between this hour and that hour. But if it's outside of that time period, your first step is to contact police. The second step is, once you've contacted police, call the police again in order to see if they can give you usually they'll create a report. Sometimes they don't for these particular instances. But if they do, you want to, sorry, I got a little bit distracted. You want to make sure that you have some record that you've contacted the police, and you want to write the letter to the landlord. I will say that nuisance issues pertaining to music is probably one of the hardest things to deal with, because again, not every attorney wants to take on that case. Attorneys are going to do jobs that get them money, and that's very unfortunate, but they have to make a livelihood. So call the police, get a running record, write a letter. If the landlord doesn't want to do anything about that issue, then it may be that you should probably I shouldn't say you should, but you may want to think about moving because it's the landlord's responsibility to control their tenants to a certain extent. And then the second question is, my house got broken into 2 weeks ago. The property management don't want to replace the broken sliding doors and windows. So Hilda, my first question is, do you have a police report that indicates that someone broke into your house? We need proof. Now, I'm not saying that I don't believe you. What I'm trying to say is we follow the proof. We follow the paper trail. If you didn't file a police report, then it's, who knows? How do we not know that you didn't go and broke into your own home? You know, I'm playing devil's advocate. So you need to contact the police, let them know someone broke into your home. And then once they create the police report, you can go back to management and say, hey, this is a damage that wasn't caused by me. This is a damage that was caused externally that has nothing to do with me, and I am requesting the repairs. At the end of the presentation, I'm going to talk about repairs. So I'm going to leave the second part of my answer to the end of the presentation, because I do talk about what are the things that you need to be doing when you want to request repairs and things that you can also do. But I'm letting you know, you need proof that you've contacted the police, that the police have created a report that someone actually broke into your home. If you don't have any of that, then that may be a little bit more difficult. So I'm going to switch gears and talk about the Tenant Protection Act of 2019, which I think is probably one of the most important things that we're going to talk about today. And I say this because this law tells us how someone can be evicted. And it also tells us how somebody can get a rent increase. There is a set of procedures. And so you're going to hear me say something called a just cause eviction. And basically just cause means that there's a specific reason why they're asking you to leave. It has to be listed on the document. And then for rent increases, it's not as complicated, but you know, again, you need to know this maximum rent increase, because sometimes I get calls where people say I received 25% increase. And so then, you know, we need to figure out, well, are you covered by this or are you not covered by this? And so I think for today, this is probably the most important topic that I'm going to discuss today, because evictions scare everybody, and evictions means that A, it can go on your record, and B, you have to move out because you may get an eviction lawsuit. And so it's usually the most important thing that I like to talk about, because it's the most immediate danger that somebody's going to have. I do see a question. Yeah, so Hilda, if you have a police report, then you should submit the police report to the property management company. And then at the end, we'll talk about some strategies that you can use with regards if they don't want to pay, you know, they don't want to make these repairs. But first thing is you need to inform the management company in writing on a piece of paper. Don't send them a text message. Don't send, you know, the manager a text message. We don't do that here no more. We do everything by the book. And by the book means you wrote a letter and you sent it to them, because you want a paper trail. And then someone is asking, I rent a very rundown old historic home that meets several of the criteria for uninhabitable. I asked the landlord to fix things, but he won't. Is there anything we can do besides moving out? It's the only housing that we can afford. Yeah, Rachel, I'm going to talk about habitability and repairs at the end of this workshop. So I'm going to keep this question here because I think you bring a important thing, but it might not be the answer you want to hear, but it's definitely something you need to know. So I'll leave this in the Q&A, but moving forward, I'm going to talk about evictions and rent increases, just because, again, it's a big topic and, you know, people don't want to get evicted. So like any law, there are certain things that exempt certain things. I know it sounds a little thingy, but what I'm trying to say is that laws are meant to protect certain, to be protective in certain situations. So there are certain things that aren't applicable, so we won't apply this. So again, for this Tenant Protection Act, also known as AB 1482, the units that you see on the screen are the types of units that we would never apply these rules to. So if you live in a single family residence, this does not apply to you. There's a different set of rules for those types of homes. If you live in a duplex, but only if the owner lives in one of the units, these rules don't apply to you. If you live in deed restricted units, so sometimes we call this low income tax credit properties or project-based housing, you will know if you live in these properties because you generally have to get recertification every year. If you don't know what that means, then you probably don't live in those types of units. And then finally, if you live in housing that was built within the last 15 years, even in-law units, sometimes we call those ADU units, are also not protected. Mobile homes and dorms are not protected. So let me reiterate this. If you live in any of these types of homes that I've listed on the screen, the following information is not going to apply to you. Okay? It is not going to apply to you because that's the way the law was written. Okay, so you can't be mad at me, you can't be mad at ECHO. You need to speak with the state government because they created these laws. And I put this out there because many of you are going to live in single family residences. That's the most common one I see where people get upset that they are not protected by the state, unfortunately. And again, So as I mentioned, the first part of this law is to address terminations, how you can get terminated. And basically the state says that there's two categories of terminations. The first type of termination is known as at fault. So basically that landlord is evicting you because of your behavior. So if they're evicting you because of your behavior, you are not entitled to relocation benefits. Nobody has to give you anything. Your behavior caused you to move out, okay? The second type of category is no fault. Basically, the termination has nothing to do with you. It has to do with the landlord. And because the landlord is initiating the termination, you are entitled to 1 month's worth of rent as relocation, okay? And I know what you're probably asking, Jonathan, well, how do I know if this is at fault or no fault? And on the screen, I basically provided you what is allowed under each category. So as I mentioned, the first category at fault means that they're terminating you because of your behavior, okay? There's 8 reasons. The first reason is because you're engaging in criminal activities. Now, I tell landlords all the time, you are not the police. You cannot say that they are engaging in criminal activities. You have to allow the police to make that assessment. The police create reports and they can tell you, but you cannot say, oh, they're criminals because they're doing criminal activities. You don't have the authority to make that decision. You stay in your lane. You let the police do their work. The second reason is there's a breach of rental contract. And as I mentioned earlier, you don't know what's on your rental agreement if you never read it. So I will say many times the issue comes down to breach of rental contract because on page 37, section 57, subsection A12 says that you could not do that and you went ahead and did it. So please read your rental agreement. The third reason is because you didn't pay rent. The fourth reason is you're committing a nuisance in the situation where a tenant is having music blasted, late at night after hours, then yeah, landlord can terminate because you're creating a nuisance for other people in the community. The fifth reason is that you as the tenant reject the written lease extension. And what I mean by this is that say you've lived there for 12 months and the landlord presents to you a lease extension and you don't want to sign it, the landlord can ask you to move because the landlord needs to secure themselves that, that you're going to stay there an additional time period that he wants based on his agreement. The sixth reason is you are illegally subletting. And I actually see this quite often in Monterey County is, people try to save money. It's natural. I mean, things are very expensive these days. And so it makes sense why some people may rent a home and then that person rents a room to somebody. But if it's not allowed in your agreement, then you are in breach of your rental contract. So you can be illegally subletting and also be in breach of your rental contract. So these are this is something that I see quite often. And I do tell people, well, are you supposed to? And they're like, no, I'm not, but things are very expensive. Well, it doesn't matter. You signed an agreement that said that you cannot sublet. The seventh reason, one that I maybe only came across it twice since this particular law has passed, is basically you forfeit the employee use unit. This is more commonly what we call the manager's unit. Maybe you work for a management company that manages properties and you live in the manager's unit and maybe you got terminated from your job. So you lose your right to this special type of unit. And then finally, one that I have been seeing a lot during the pandemic has been, you don't allow the landlord to access the unit, only if they've given you the 24-hour notice to enter. You're refusing them access and, consistently means that you are also most likely going to be asked to leave through a termination notice. So as I mentioned, if you fall into one of these 8 categories, you are not entitled to relocation benefits, unfortunately. Now, the second category, known as no-fault terminations, there's only really 4 situations. The first one is that, the landlord is removing the unit from the rental market. In other words, they don't want to be a landlord no more. And they have a right to say that. They don't want to be in this business anymore. And so they can remove the unit from the rental market. Maybe the landlord will move into the unit. And this also includes children, stepchildren, parents, grandparents, step-parents. It kind of goes hand in hand with, removing the unit from the rental market. Maybe the unit is unfit for habitation. And so this has to be for issues pertaining to habitability, but that have not been caused by the tenant. In other words, the home's condition without you ever doing anything is not habitable. And so the landlord can actually ask you to move out. The best example that I can give you is, say there's a thunderstorm and a lightning strikes the roof and the roof caves in. You as the tenant had no control over the lightning strike, but now the home is not habitable and the landlord can actually ask you to leave because that then becomes a liability for them. And then finally, the unit will be substantially renovated. I will say the most common one is going to be these 2 that I see often. And however, if you do receive a notice of any of these 4, you are entitled to relocation benefits equal to 1 month's worth of rent. So as I mentioned, relocation benefits, if you are being evicted only for no fault, then you are entitled to 1 month's worth of rent. And again, this only applies to units under AB 1482. So if you live in that single family residence, you're not protected under this. You don't get relocation benefits, unfortunately. So terminations that are not covered under AB 1482. So if you live in that single family residence and they're asking you to leave, they don't have to give you a reason. So you are not afforded the right to know what the reason of the termination is. So they can just write on there, here's a 60-day notice and you gotta move. No reason. You are not entitled to a reason. However, I tell landlords, I tell managers, give them a reason. It is just courteous for them to know why is the reason they're asking to leave. And again, this is not going to apply to single family residences. Also, townhomes and condos are also exempt because those are considered single family residences. And you are also not entitled to relocation benefits. So you don't get anything. I know, a little harsh, but that's the way the law was written. So one thing that I like to talk about is called the termination notices, and I call this the 30, 60, 90 rule. And so in order for the landlord to terminate you, the landlord is obligated to provide you a written notice of the termination. And so one of the things I look at is, how was it served to you? Because the service of the termination must be correct in order for the termination of the 60 days, 30 days, or 90 days be correct. So they go hand in hand. They not only have to give it to you on writing, but they also have to give it to you correctly. And so valid forms of serving include they either personally serve you, they mail it to you, and the most common, but also the most common way people get this wrong is called a posting and mailing. As you can see, it's called posting and mailing. I can't even tell you how many times I've told managers that you have to do both. If you're going to post it on their door, it also has to be mailed. If you only post it, it's not valid. You have to do both. And then finally, the substituted service. So this 30, 60, 90-day rule is going to depend on how long you've lived there. So if you've lived there for less than a year, you get 30 days. You get a 30-day notice. If you've lived there for more than a year, you get 60 days. And then if you live in Section 8 or project-based housing, you actually get 90 days, regardless of if you've lived there for less than a year or more than a year. So one thing I get asked often is, well, Jonathan, I lived here for 15 years. It doesn't matter. You get 60 days. That's what the state says. That's what you get. The state does not care that you've lived there for 15 years. The state doesn't care that you've hoarded 15 years worth of stuff. You got 60 days to move your stuff or you will get an eviction lawsuit. So I always tell people, when you get this notice, you need to take it seriously, but you also need to begin to pack, because there may not be a guarantee that you will be getting more time. And if you can't get more time and you go through the eviction lawsuit and you lose, the sheriff is going to be knocking on your door telling you, you got to move right now. So invalid forms of service, these are kind of the most common things I see that I always have to speak to managers about, is if they email it to you, text it to you, or tell you in person or over the phone. I know in this day and age, most of us text, but unfortunately it is not a valid service. So they cannot email it to you, text it to you, or tell you over the phone or leave you a voicemail. It has to be on a piece of paper. And as I mentioned in my previous slide, they either have to give it to you in person, mail it, they can post it as long as they mail it, or they do a substituted service. If it's not one of these four, it's not valid. So the second part that I think is important as part of this particular state policy is increasing your rent. And so the state says that there is kind of a math equation in terms of how much they can increase your rent. The rule is 5% plus CPI. Okay, so CPI is just a fancy term that we use, but all it means is inflation. So I did a little bit of digging before we had this presentation, and the current CPI for Monterey County, I believe, is 4.9. And so the maximum rent increase is 9.9%. Okay. And so right now, if you live in an apartment complex, you can get up to 9.9%. They are allowed to do that. I will say that the CPI does change throughout the year. So right now, the May one is not published, so it probably won't be published till June. And so say the next published CPI says that the CPI is 4%. So you're going to do 5 plus 4 is 9%. So it would be 9%. But as of right now, it's 9.9%. So I know rent increases are a hassle, because I always tell people, just because you get a rent increase doesn't mean that your income increased, so it's harder to budget. But unfortunately, the state does allow landlords to increase the rent. Now, one thing I want to mention is that if you live in an apartment complex, as I've been talking about, this particular policy, the maximum they will ever be able to increase your rent is 10%. They can never go above 10%. So if you live in an apartment complex and you receive 12%, give us a call, because we want to talk to the managers about that. That's not allowed. Obviously, there'll be extra questions that we'll be asking. For example, do you provide project-based housing? Is this a low-income tax credit property? Because if it is not, then they cannot give you 13%. It has to be 10% maximum. One thing that a landlord must do is that they say they're exempt from AB 1482, which is the policy we've been discussing, is they have to provide some written notice to the tenants, basically saying that they are exempt. This is the language that they should be including that says that they are exempt. I know that in Monterey County, we have received certain calls where the tenant is saying, hey, we never received this information. And so this is what I tell tenants, or this is what we should be telling tenants. You have a right to make that argument, but you will have to make that argument in court, which means you will have to wait till you get an eviction lawsuit to raise this issue. Eviction lawsuits can be scary because in Monterey County, there's not a lot of legal aid agencies. I think the #1 legal aid agency is CRLA, but unfortunately, it's a small office, so they can't take on every eviction case. So you may be on your own unless you hire an attorney. And again, for some people, it may not be worth fighting over this language, because they can just reserve you with the language and basically continue the eviction process. So it's not going to stop the eviction process 100%. They just have to reserve you. So you as a tenant need to decide if this is a battle you want to fight, because if this is a battle that you want to fight, you may be fighting it alone. There's not a lot of attorneys in Monterey County that represent tenants. And legal aid agencies generally don't represent tenants simply based on this language. So just keep that in mind. Usually the question that I get is, how often can the rent be raised? So under the state policy, they can raise the rent twice in a 12-month period, so twice every year, but the increase cannot exceed the cap. So what I mean by this is, say you got a rent increase in January that was 3%, but then in July, they found out that the maximum was 10%. They can't increase your rent 10% more, because that would make it that in 1 year, you increase the rent to 13%. And as I mentioned, the cap is 10 every year. The cap can only be 10. So if they raised it 3%, but the max is 10, they can still raise it an additional 7%. Okay. And then because they can only increase it 10%, you are only entitled to a 30-day notice. So they'll give you a 30-day notice. They don't have to give you 60 days. They don't, they don't have to be courteous to you when they give it to you. They just have to say, here's the 30-day notice. We're increasing your rent. You may not like it, but that's the reality of renting. When you rent, you are subject to these rules. One thing is there's no vacancy control in Monterey County. And what I mean by this is that if somebody moves out and they were paying rent that was $1,200, but then the landlord rents it to somebody else, they can charge $3,500 if they wanted. The law does not say that they have to continue to rent at $1,200 once the tenant leaves. And that's just unfortunate, and especially in Monterey County where a lot of people left the Bay to move to Monterey County, and it's driven up those prices. It's really difficult. So, as I mentioned, this previous policy, let me go back because I want to make sure we are all on the same page. Because I know people are going to call me tomorrow and they're going to say, well, didn't you say that I get 10%? Okay, this policy here does not apply to these properties, okay? Sorry, but you're not protected here. That's just the way the state wrote it. So I hate to be the bearer of bad news, but too bad, so sad. You're not protected. However, let me go down. Right here. However, with rent increases for single family residences, as I mentioned, they're not a covered unit. So there's no maximum rent increases for these homes, which means that you will receive a 30-day notice if the rent increase is 10% or less, which is the standard. But something that's new is that if you receive a rent increase greater than 10%, they have to give you 90 days, okay? It used to be that you would get a 60-day notice, but the law changed back in 2019, right when the pandemic started in 2020. The law said is that if you get something more than 10%, it is 90 days. So these days, we don't see 60-day notices for rent increase because they don't exist, because you're either going to be a covered unit under AB 1482, which is the maximum 10%, or you're not, which is either going to be a 30 or a 90-day notice. And then something that I see often, actually, I see this a lot, at least once a week, it's lease extension. So if you get a lease extension and it has a rent increase, they have to follow the rent increase rules. Many times what landlords do is they'll email you the lease extension and it has a rent increase. Nope, they have to give it to you on a piece of paper. They either have to mail it to you, they can post it and mail it, they can personally serve you, that list of valid services. It applies to rent increases. So many times I do have to call managers and say, like, you didn't do this correctly. Like, you're getting paid to do the process correctly and you're doing a bad job about it. I have questions to ask you, which is, how did you get this job? Because you only got one job and the job is to read what the policy states. You can't come up with rules just to come up with rules. You have to follow these rules. And it gets me really irritated with these lease extensions because managers will say, well, this is standard. Well, so breaking the law is standard is what you're telling me, because you haven't been following the rules. And they don't like it when I call them because I'm not nice to them, because they should be doing their job. They have one job and their job is to understand these rules. They're in the business of renting or assisting as an agent, then they should know these rules. So please, if you get a lease extension and it has a rent increase, they do have to follow the rent increase rules. They're not special. These are not special people. Other things that I think is worth mentioning is there's a state law that says that they cannot discriminate against you just because you have Section 8. As a matter of fact, that is a fair housing law now embedded in the state of California. So essentially they can't advertise or they can't tell you that we're not going to rent just because you have Section 8. That is illegal for them to say. And then the second one that I already talked about was that they do require 90-day notice of rent increase if they're increasing your rent more than 10%. So I said for properties exempt from AB 1482. So as I mentioned, this is for single family residences. So if someone is writing, I live by the ocean and therefore there are a lot of seagulls on our roof. Is the landlord required to put a deterrence for the seagulls? No, you moved out to the ocean. I mean, okay, people, this is the kind of questions I like. You live in an environment where there's birds. You moving there came with the understanding that you would accept the environmental conditions. So no, the landlord is not responsible for the seagulls. If the seagulls bother you, you can move. And I know that sounds harsh, but I have to be very straight about it because you moved into a home where you knew that was the environment. Flat out, you knew. There's no secrets. When you go to the ocean, when you go to the beach, you'll see a lot of sand, you see a lot of birds, you see a lot of traffic. You knew that. So no, the landlord's not responsible. You are responsible. And if you're going to put something on the roof, I recommend that you definitely speak with the landlord before you make any modifications or changes to the roof, because, if I was owning that home and you all magically put these posts and put nets on there, I would be upset because probably somewhere in your lease says, any modifications to the home needs approval by the landlord. But in short, unfortunately, nope, the landlord's not required because you knew exactly what you were moving into. It's like asking to move to somewhere super hot, like really hot, like Bakersfield. And you're unhappy that it's super hot in the summer, it goes up to 110 degrees, and you're like, well, isn't the landlord supposed to put an AC? Nope, the state of California says ACs are not required. So there you are. You went and moved into a location that is super hot in the summer and you don't have an AC. The landlord's not responsible for that type of repair or addition to the home, unfortunately. I know I'm very harsh with my responses, and that's because I cannot stress that many times this is black and white. A lot of people like to make it gray. I don't like to make it gray. It's black and white. It's yes or no. And unfortunately, that's the way things are. We can help with neighbor disputes. It just depends on the type of dispute. So for example, if this is a neighbor that is also a tenant in the same property complex, we can. But if say you rent a house and this is just with the neighbor that owns their home, we tend to not get involved at that point because it's no longer a tenant issue. It's really just you against an owner at that point. But it's worth a chance. I mean, give us a call. You will most likely talk to either Christina Soto or Eliza, who are the housing counselors out in Monterey County, and talk to them. Give us a call, and I'll put my contact information at the end. I can't, sometimes we do get involved, sometimes we don't. One thing that we do here is we do mediations, and so most of our staff are trained mediators. And so we always try to help mediate situations so people don't have to get displaced, people don't have to go to court. And it's a good way for people, for both parties to just have a conversation without feeling the stress of needing to yell at each other or use bad foul language. I know people, I like to say bad words. I'll be the first one to admit, but it doesn't help us in a situation when we need the other party to understand us. And so mediation is a good tool if it can work for you. let me move on. Any questions? I should have put this a little while ago, but I wasn't paying attention. Any other questions? Please submit them in the Q&A box. Okay, it looks like we do have a question. Okay, so if you're on a month-to-month lease, rent increases are the same. The only question I have is, what kind of home do you live in? Is this a single family residence or is this an apartment complex? Is this a duplex? I can't really answer that question without knowing what type of property you live in. And then, I spent what, 12 minutes talking. Okay, so you live in an apartment complex. Do you live in project-based housing or low-income tax credit property? If you don't know what that is, okay, great. So basically, they just have to issue you a 30-day notice, and they either have to give it to you in person, post it on the door and mail it, or mail it to you. The rent increase maximum right now is 9.9%, which means that they just have to give you a 30-day notice that they're increasing the rent. So for example, if they give you the notice June 1st, you get 30 days, and then they can notify you. Basically, they're telling you that come July 1st, you would have to be paying the rent. So that's how rent increases work for apartment complexes. So we're gonna talk about repairs and habitability, and I know that there is a question that I left in the queue. No, so they cannot increase the rent 9.9% every month. It's 9.9% as of right now for the next 12 months. So it is twice, they can increase it twice every year, but it cannot go above 9.9 cumulatively. So what I mean by cumulatively is that if, say, tomorrow they increase your rent to 9.9, they cannot increase your rent to 9.9 again. They've already reached the max for the year. Well, technically, they haven't reached it because the max is 10%. So they can actually increase your rent again one more time to 0.1%, but it's probably not going to be worth it. So it's not, yeah, it's not every month. They can increase the rent twice a year, but it cannot go past the maximum. If they reach the maximum the first time, they can't increase it again that same year. Hopefully that makes sense. And then if you have two adults over 18 on the application and living in a unit, but one of the applicants dies or moves, is the remaining tenant still responsible for the entire rental amount? Absolutely. You are absolutely responsible for the entire rental amount. This is what happens when you signed a lease agreement with other people. You are responsible for the full amount. So when you sign that agreement, you agree that you are responsible for that rent, regardless of whether the second person moves out. If they unfortunately pass away, you are responsible for 100% of that. It's like if you go buy a car. If you go buy a car and you co-sign for somebody and that person does not pay the car payment, guess what? They come after you because you co-signed on that car. So this is the exact same concept. You are 100% responsible for that rent amount, unfortunately. So I'm going to end this presentation and talk about repairs and habitability. So there's a term called habitability, which basically means that the unit has to be fit for habitation. And what is defined as habitable really depends on state and local building and health codes. And so one of the things that the state of California says is that the landlord has a responsibility to make repairs that make the unit unfit for to live in, which is what we use the term as uninhabitable, okay? So there is a famous California court case called Green versus Superior Court that basically said that all residential leases contain an implied warranty of habitability. So even if your rental agreement is verbal, the state of California says that there is this implied warranty of habitability. And basically what it is that the landlord is legally responsible for repairing conditions that affect the unit's habitability. So you don't actually have to have an actual written contract. Basically, the state says that if it is recognized that you are the tenant because you pay rent and you live in a unit, then this implied warranty of habitability is inherent to that type of contract. And so it is always critical for a tenant to make requests for repairs to the owner. So as I mentioned, we don't do talk no more. We don't send text messages. We don't send emails. We don't do none of that stuff. No, please get that out of your minds. We don't do verbal communication, none of that stuff. We are all adults here. We need to do things by the book. And as I mentioned, it is important to ensure that the request be made in writing for record keeping purposes. You need to protect yourself. You cannot believe how many times I have to deal with a particular situation because the tenant said, well, I always told them over the phone. Okay, well, too bad, so sad. Like, I can't do nothing about that. You don't have proof. I'm not going to go stick my neck out. I want to see something on a piece of paper. Unfortunately, this is the world we live in, and you need to do things on a piece of paper. One thing that I do mention is just because the home is not perfect or aesthetically pleasing, it doesn't mean that the implied warranty of habitability has been violated. So I do tell people it can't be for cosmetic reasons. It does have to do with like serious habitability issues that affect the livelihood of those that live there. Someone is asking me about rental revitalization grants or funding for landlords. So in Monterey County, not that I know of, unfortunately, I mean, for appliance upgrades, I know that PG&E is one that does provide those types of upgrades, but not necessarily any grants. Those would be like city specific if the city has like a type of grant, but I'm not aware of any in Monterey County, unfortunately. One thing that I do know, and again, I play devil's advocate. You as a landlord have a responsibility to upkeep your property. The expectation that there is like grants out there to make the repairs is not fair. You entered to purchase a home knowing the condition, so therefore you have to maintain the condition. I do know some cities, obviously not in Monterey County, where they do provide these types of grants and funding, but not necessarily to like repair the roof, because repair the roof can cost you well over $15,000. I know that there are loans. You can go speak with a loan officer because there are some loans where they do allow for repairs or upgrades on homes. But again, not everybody wants a loan. Everybody wants free money. I'm not gonna lie, I want free money too. But unfortunately, I do not know of any in Monterey County. Actually, what you can do is call the city you live in and see if they offer anything. I should have said that from the beginning, but that's probably my first go-to is see what the city offers. Maybe they do. They just don't advertise it. I know some cities do weird things and they don't advertise much, but they have a program like that. A very good question. So a unit may be considered uninhabitable if it lacks the following, and this is a short list. So this is not extensive, but these are the kind of things that I see quite often. If there's waterproofing of roof and walls, including unbroken windows and doors, and I know this was an issue with somebody that asked earlier about, breaking into the home. Number two, if there's not working plumbing, meaning you don't have hot water or cold water. I think that's something I see here and there, but I think, to be honest, the one that I see quite often is going to be number 3, is like people don't have a working heating facilities. So, you don't have a heater that doesn't work. That's a serious issue. It's funny because the state of California says having a heater is mandatory, but not ACs. This also includes electrical systems such as lighting and wiring to be in working order. And then the third one is adequate trash receptacles. So free from debris, rodents, and vermin. Again, this is just a very, very short list. There's an extensive list out there that basically outlines things that make it uninhabitable. So what do you do if the owner does not want to repair? And this is my favorite one because landlords don't like this, and landlords get a little testy about this, but I tell landlords all the time, look, you don't want to make the repair, your tenant has a right to do this. Pick and choose your battle, and your battle is you want to be too cheap to make the repair. So guess what? Your tenant's going to force you to make the repair. So under the state of California, you have 2 remedies. The first remedy is known as the repair and deduct remedy, that basically says that you as the tenant can deduct money from rent to pay for the repair if it does not cost more than 1 month of rent. In other words, it's got to be, less than your rent. Cannot be used for more than 2 times a year. And then you do have to inform the landlord of the repairs first. So you do have to make the request for the repairs. The first thing I'm going to say is, how did you make the request? If you tell me, well, I called my landlord, and I'm going to say, too bad, so sad, you did it wrong. You need to write that formal letter. Again, if there's anything I've told you today, is you got to have everything in writing. I don't care if you got to go to your neighbor and ask them for a piece of paper, go to the other neighbor. If you go ask them for a pin, you need to write things on a piece of paper. So that's your first remedy. You can repair and deduct. The second remedy, which I think is probably the strongest remedy, but it's also the remedy people get upset with, or landlords get upset with, is called the rent withholding remedy. So basically, you stop paying some or all of the rent if the landlord refuses to repair. I always say, if you're going to use this method, you need to save your rent and not spend it. And why I say this is because once they make the repair, you got to pay the landlord the money you withhold. And many tenants get upset because what they'll do is they'll withhold the rent, and then they'll go on a shopping spree. They'll go buy Givenchy, Yves Saint Laurent. They'll take a nice trip to Vegas, and they will buy everything Louis Vuitton. They'll come back home, everything gets fixed, and then they're forced to pay the rent. And they're like, Jonathan, I spent the money. Well, you better start packing your bags, because that eviction notice is going to come very soon. So if you're going to use this method, you need to save the money. Do not spend it. I don't care if there's an emergency. What the emergency you're going to have soon as well is you're going to be having to pack your bags, because you're going to owe that money once they fix the repairs. Landlords hate the second option because it's the most aggressive one, and it really forces the landlord to make a decision. And again, the state of California says that they can't retaliate against you. And many times when you get an eviction lawsuit and they're going to say, well, they didn't pay their rent, you go to court and like, yeah, I didn't pay my rent because I asked for repairs. Here's the proof that I asked for the repairs. Here's the proof that I told him that I was going to withhold rent. He still didn't make the repairs. And here we are in court and he's retaliating against me. So the whole idea is to protect yourself. So as I keep mentioning, in every slide, you have to have everything on a piece of paper, unfortunately. And I think we have a few questions. And I think, the very first question that Rachel asked about, this being run down and whatnot, here's what you can do. You write a letter and you decide what to do. You can use these remedies. Again, I always tell people there is a risk associated with using these remedies. And that is you will be presented with an eviction notice or a termination notice. It is up to you to decide how you want to fight this. If you feel that they're in the wrong, you can wait for the eviction lawsuit and then fight the eviction lawsuit. Please, please keep in mind that there's not a lot of legal aid agencies in Monterey County. So do not expect that a legal aid agency is going to come and save you. If you're going to use one of these methods, you have to think 3, 5, 6 steps ahead. And one of those steps is that you're going to be able to defend yourself in an eviction lawsuit. So again, the law doesn't care about anything else. The law says that, you know, you have a right to make requests for repairs. You can use these remedies if you want to, with the known risk that you can receive a termination notice. Right. So actually, so Rachel, with withholding, landlords don't have to give you a reason to evict, but under the retaliatory clause, they can't really evict you if you made a complaint against repairs. So they give you like 180 days. They can say whatever they want, but at the end of the day, you know, you have a right to defend against a retaliation. And there's like, and you point out a really good statement there is that there's, you know, sometimes there's no accountability, and a few lawyers will represent renters. That is true. And this is why I say that you have to think about steps 3, 5, 6, 9, and 10. It's not just thinking about that you're going to withhold rent. You have to think about everything else and the consequences associated with that. Not everybody's willing to do it. So you have to pick and choose the battle that you're willing to fight. I have some tenants that they're like, you know what? I'll wait for them to take me to court. I'll make them look like clowns, and that's perfectly fine. But it's, you know, if you're afraid and you're afraid that you're going to go into a termination and you know that you wouldn't be able to afford an attorney and you think that none of the legal aid agencies are going to help you, then the question I pose is, please think about if this is the battle you're willing to fight. You have every right to request repairs. As the state has said, you have every right to withhold your remedies, or not withhold your remedies, withhold your rent or utilize one of these remedies. But what you do after is up to you to decide. And so it's not as easy as if you lived in the Bay, where there's 12 legal aid agencies that handle evictions. Unfortunately, Monterey County doesn't have that kind of legal aid infrastructure that can assist people in these particular situations. But you definitely bring up a really good point. And it looks like, you know, Pacific Grove does have a housing rehab loan program. Yeah, so this is what I'm definitely talking about, is that cities will have these specific types of programs, but is loan-based. I always tell people there's nothing free in this world. We cannot be expecting free money just because we want to upgrade a home. Unfortunately, you know, that's just the way things work. I'm sorry, folks. You know, I wish everybody had resources to be able to upgrade the homes, fix things their home. You know, I'm a true believer about community assistance, but in this world, society is not equitable. Let's just put it that way. So the other strategy with regards to repairs is always filing a complaint with the county or the city code enforcement department. So code enforcement is basically a department within the county or city. I'm not sure if the city of Pacific Grove has a code enforcement, but if they do not, then you would call Monterey County's code enforcement. And what Monterey County's, or what code enforcement does, is that they are the people or the department that investigate violations to building codes or health and safety codes, specifically for housing as well. And so if this is like someone who mentioned about a house that wasn't, you know, was kind of run down at this point, code enforcement would be the people that you can call, because they will send an inspector. The inspector will make an evaluation. They will have a report. The report will go to the landlord that says, hey, you have all of these code violations. You need to fix these issues. Yes, so someone is saying, that Pacific Grove has code enforcement. So beautiful. Thank you so much, whoever's posting that. I definitely recommend that you contact them. Now, here's my tip. If code enforcement's saying, oh, we don't investigate that, tell them that you need to speak with the supervisor, tell them that you want to speak with the city mayor. You want to make them aware that code enforcement needs to do this kind of work. Across the US, code enforcement and cities have been sued because they don't do the inspections. So why are cities funding these departments if they're not willing to do the inspections? There's a lot of cities that have been sued. A good example is my good old friend out in Bakersfield. Kern County Code Enforcement was sued and they lost because they weren't doing inspections. That's the whole point of code enforcement. Obviously, a legal aid agency would have to sue them, but that's a different story. But essentially, this is going to be your best option. I'm sorry. Now, one thing to keep in mind, and there's always a risk. If code enforcement goes out into the property and they find that unit or the home is severely uninhabitable, you can run the risk of being red tagged. And when I say red tagged, meaning that they essentially post a sticker saying that no one can live there, that it is in serious violations of these codes, that living there poses a serious threat to whoever lives there. I say this because I have seen this time after time where sometimes the unit is red tagged. So that means that they may say, hey, I'm giving you 20 minutes to get what you can right now, but you're not going to be able to enter the home anymore. So you will be forcefully removed because the unit is severely uninhabitable. So I say that because, again, it is a risk that one will have to assume. So that kind of concludes our workshop. Yes, it was about an hour and a half. Our contact information is on the screen, and I do see somebody who asked, if you need assistance in Newark, Hilda, I recommend that you reach out to us. We actually do serve the city of Newark out in Alameda County. You can call the number on our screen, and we're more than happy to connect you with a counselor out in Monterey County. Absolutely. I know that we talked about a lot of things today, Rachel. I always tell people I give you the surface information, the stuff that I feel is very important. The nooks and crannies, let us do the work for you. Because each situation is different. There are some nuanced details that I don't give because sometimes they don't come up, sometimes they do. And I'd rather people just have kind of like a good basic understanding of certain things. So that concludes our workshop. So, if there's no other questions, you are free to log off. I'll still be on for a little bit until we see that no one's asking any more questions.